In determining how you're going to divide an asset, a critical question is whether you executed a prenuptial agreement and whether that agreement is enforceable under New Jersey law. If you executed an enforceable prenuptial agreement, then the distribution of assets will follow that document. However, if you executed a prenuptial agreement that is ultimately deemed to not be enforceable, then the asset allocation would follow the statute. Prenuptial agreements are something that should be considered very early on, but unfortunately are not. The enforceability of a prenuptial agreement is going to be guided really by the statute. And what that says in very sum is that it has to be conscionable. It has to be executed with two counsel having reviewed it. It has to provide for an outline of all of the assets and liabilities of each party. And at the time of enforcement, meaning when you want it to be enforced, it has to be equitable. Mediation is an encouraged and better solution to litigation. Any issue can be resolved in mediation, whether it's support, distribution, custody, parenting time, everything can be resolved in mediation. It's the decision of the parties to come to the table and find common ground. If you have been unable to find common ground and you're therefore not able to agree on how to divide your assets, then that issue would go to trial. A court would ultimately decide how your assets are going to be divided, meaning who's going to keep what, what's going to be sold, and how much, by way of percentage or dollar amount, are each of you entitled to receive through that distribution. That would be guided by the statutory factors.